I always think that if a person has no criminal record whatsoever, that they should be speaking to an attorney before trying to handle any criminal charge, because it's important to be able to answer a question on a job application, have you ever been convicted of a crime? It's important to be able to say, no, I have not. Nothing is going to necessarily prevent the government from charging you with a crime, but a charge and a conviction are two different things. And so if you've got a clean criminal record, why not speak to an attorney to see if we can keep it that way? Rather than just kind of taking the path of least resistance and going in and saying, well, they're not telling me I have to go to jail and this is a slap on the wrist. Well, that may be true. You may have to pay a fine or write a letter or do some community service, but at the end of the day, the thing that's really going to come back to bite you is that record. And so I would say that no criminal charge should be handled, as we say, pro se, or in other words, by the person, if it is their first one. But as time goes on, if a person starts to accumulate multiple criminal charges and they kind of understand the nature of the system, they can evaluate for themselves whether or not on their, second or third shoplifting charge or driving over 100 miles an hour, they can kind of figure, okay, well, I can do this without going through the process of obtaining an attorney. But generally speaking, I think it's always a good idea to at least consult with an attorney before you go forward with disposing of your criminal case. And that's just a simple precaution that people should take because of these collateral consequences that can sometimes come back to bite you. Whether it be driver's license suspensions or loss of firearms rights or just the simple fact of having a conviction on your record. These are all things that are worth exploring with an attorney before proceeding on your own.